for the matter of Dominic Jones versus Montel Jones, 45C01, 1106 DR 465. For the record, will they identify themselves and who they represent?
Lonnie Ranoff on behalf of Ms. Dominic Jones, Your Honor.
Christina Garza on behalf of Father Montel Jones.
Okay. And we're here for status?
That's correct, Your Honor.
I think so, Your Honor. The only thing, what I can recall, Your Honor, is that we had a hearing last month, and then the court issued an order.
Right.
And the one again says the husband should provide to wife proof of the life insurance policy in an amount no less than $35,000, naming the party's minor child as a primary beneficiary. And I think I recall counsel did sent notice to me that that is in fact the case. They've done that. That the husband was found to be in arrears and his child support obligation, a sum of $572.10 for the year 2011, and the sum of $801.29 for the year 2012. However, there was evidence presented for each of the years in question demonstrating that the required amounts representing child support were in fact withheld from father's wages but never received by the wife. Husband and wife are ordered to cooperate in taking whatever steps necessary to resolve this issue and purge husband of the contempt. Furthermore, either party may petition the court for further proceedings on this issue if necessary. Husband's ordered to pay $1,000 of the wife's attorney fees. Husband's request for attorney fees is denied. I think there was a petition that we had filed for rule to show cause, Your Honor, for support arrears, and a wife had indicated that after their divorce, I think the divorce is 2004.
He was sick or something. He was supposed to be withholding payments,
and she was
and she never received them.
Yeah, and I think we had estimated about $30,000 or $40,000, and they said that they had been paying
$40,000.
So I don't know where we are with that. I mean, how can we show that in terms of that?
Well, if I may, Your Honor, what has transpired in the interim is we had this hearing, final hearing on father's petition for modification of custody. We did enter into a series of stipulations. The parties also had previously negotiated and submitted through Dr. Joe Miller parenting time calendar, and we had several issues that were before the court. Obviously, the issue of a modification of child support and all the things that triggers, the tax exemption, retroactivity, arrearage issues, and also at the final hearing, wife filed her rule to show cause. It appears from the court's ruling that only those issues that were addressed in the rule to show cause were ruled on. So as a result of that, husband filed a motion for entry of non-protunct and or motion to reconsider, just basically asking the court to rule on the other issues that were before it at the final hearing. And I've outlined those in paragraph 9 there on page 2. As to the other issues that were addressed in the court's order, to be candid with the court, I advised my client to hang on a second until we had all of these issues resolved, and then we would go forward from there. But we did provide the proof already of the life insurance policy.
I'm getting kind of confused now, Your Honor. My understanding was that the domestic video that set up the criminal time, they submitted a recommendation, the parties accepted that, so that's not an issue.
That was my recollection. I could be wrong.
That is correct, but the court has never formally adopted that.
All right. Okay. We'll show that that's formally adopted today. So that takes care of the parenting time issue.
Yes. And also we had submitted to the court the stipulation that mother would maintain primary physical custody and the parties would share legal custody. And again, I don't think that was formally adopted.
Okay, then we'll do that. All right.
Okay.
Now you got your husband's recent checks to us from Ford Motor Company.
Those were submitted at the final hearing, Your Honor.
Yes.
And they reflected basically a 40-hour work week, which would have caused his child support to be decreased. and we submitted a proposed child support worksheet for 80...
Is this the one?
No, that's yours. And see, my issue that I have, Your Honor, is if these matters aren't dealt with,
I agree.
then we're just coming back.
All right. So you have child support and your proposed worksheet.
Yes, we had submitted his most recent check stubs, a proposed child support worksheet at $85 per week. We were asking for retroactivity back to the date of filing, which would have caused a $2,003.96 arrearage. And given the relative percentages of their contribution towards support that's reflected in that worksheet, we were asking that husband be entitled to claim the child every year for tax purposes. And we did ask for attorney's fees, and the court dealt with that in paragraph 4 of its order.
Mr. Randolph?
My recollection, Your Honor, I can't, and I don't recall exactly which W-2 worksheet you showed, but my recollection shows that the husband made, in 2011, $113,000, I believe, was his annual income.
How much?
$113,000, $107,000. That was my recollection of 2011. Am I incorrect on that?
I disagree with the number,
Well-
but it was more than what he is currently making, and that was part of the reason that we submitted the most recent check stubs. What he testified to is that Ford has hired a third crew, and as a result of that...
Right, he wasn't getting the overtime that he was getting
Yes,
before.
and he was only working about 40 hours a week.
And he was making $28 and some odd cents an hour,
Correct.
and 40 hours times that, so what's the weekly...
I think it was, I think it was either $11.25 a week, something like that. But what I'm basically asking the court to do is to simply review the evidence presented at the hearing and rule on those other issues, so that we don't have to file new petitions. And if it would assist the court, I don't have a problem in filing proposed orders to refresh the court's recollection about what each party was proposing, to maybe facilitate.
Can we stipulate to the hourly amount that the husband receives, which is, I think, is 28, and then the court can go by that based on an hourly 40-hour work week, what his wages would be?
He earns $28.125 per hour.
But we agreed on he was working only 40 hours a week.
No problem with that.
Okay,
Fine.
so that you can put that in a proposed order and the calculation, make sure Mr. Randolph agrees with your calculations.
In reference to the exemption for the child, Your Honor, our position is that the mother should maintain that on a yearly basis. Why? Because of disparity in terms of income. I think she was making, her income was like $18,000 and then $25,000 now that she makes. And he makes substantially more than she does. And so in the past, since the divorce, she's been taking the exemption. So at this point in time, there's no legitimate reason for a modification of that to give it to the husband, considering the fact that we've got an issue concerning whether or not he's been consistent in support in the first place. Plus, I believe they have an obligation to show for him to even argue that he has been paying support at least with 90 or 95%, I think is what the case law indicates.
I think it's got to be current, 95% of the time? Or?
Yes. Yes, and Your Honor, that was produced for the court. I think what the court had basically indicated was that apparently there's some discrepancy. All of the paychecks
Right.
that were
We don't know
submitted...
whether he got, has that been cleared up? The issue as to whether they're withholding it and she got it or they somewhere.
It hasn't, Your Honor, because of all these other things that arose.
All right.
I think the court just ordered the parties to cooperate in sorting that issue out, and we have no problem with that. But from what was presented to the court, Ford has appropriately withheld the sufficient amount of support. The issue is whether or not the clerk has forwarded it to Mom. Or, I'm sorry, it wasn't, this didn't go through the the clerk here in the county.
The employer was supposed to withhold it and send it to the clerk, I guess.
Correct. Because this was a domesticated judgment and it came from Illinois, Ford, it's my understanding Ford is still paying the clerk in Illinois, and that's the problem. We couldn't obtain those records here.
Now I remember. They were paying Illinois.
But how, so you'd have to file something in the Illinois?
He has to find out where the money went, right?
I think Mom would be the person that's best able to do that because it's her account.
No, it's on you. You get to show
Well, wait a
you've been paying.
minute. If the money went to Illinois and it's in her account, she's right. She'd be the one that could go and see if the money's there. Has she done that?
In her account, I'm trying to get a definition of account. What do you mean? her
Well, I mean, when the money goes to the clerk's office, it's in, she's the payee that the clerk would send a check to.
If in fact there's been a wage withholding.
If it's the money's there.
Yeah.
If the money's there, it would be in her
Yes,
name.
there was a wage withholding order. We submitted to the court that he was current.
I mean, was there a wage withholding order that was submitted to the court verifying there was one that was in Illinois? I don't know that.
It's being paid to the clerk in Illinois. Ford is doing it pursuant to a wage withholding order.
Okay, and you've got a copy of that? Will you show it to the court?
I don't.
So our burden is...
If I remember the evidence, it was that money was withheld, but she testified she never got it. So if it was held by the clerk in Illinois, she would be the payee, I would have.
And
Correct.
I don't know how she has that set up, but typically she could have it direct deposited into her bank, which would then be producing her bank records or reviewing her bank records. So she would be the party that's in the best possible position to find out.
Okay. So she would go to the clerk's office, see
I
whether...
mean, what I meant for cooperation was that if he needed to do anything with Ford to find out if the money was if anything they did on their end, because he's the only one that could do that. As far as the clerk in Illinois, she's the one that could do that.
So she would be...
That's why I said they should cooperate, because they both have to do something.
So she'll be charged, so there's no misunderstanding, with going to the clerk's office in Illinois and finding out whether or not, with the case number, finding out whether or not there's been a support paid to that. And in the meantime,
And they'll give you a printout of everything that's been paid. And then,
yeah, and that'll deal with the support issue, rears issue.
Right.
The current support, there's be some issue presented by council showing the 40 hours a week at $28.16 a week for him.
right.
28.125. I think,
So I suppose there would have to be another wage withholding order done and all that?
yes, and I don't have a problem with that. I thought one of the issues where council and I disagreed was the number of overnights. And when the parties did their parenting time calendar, they did it from that point forward through the end of the year, which I think was only 9 months rather than 12 months. So in husband's proposal, we simply continued at the same schedule, and we calculated 138 overnights. But if I recall, I thought council disagreed with that, and that was why we...
That he should get credit for 138 days overnight a year?
Yes. We were just simply going based on the party's parenting time calendar that was filed and submitted with the court. And they have followed that parenting time calendar, as far as I'm aware.
The child's in school at least 9 months, not counting summer school. And so how are you going to get 65 days?
138 nights.
138 is based on their parenting time schedule. They deviated from the parenting time guidelines. There was additional overnights that were permitted.
That's not practical.
But if we've
What is the
stipulated...
parenting time schedule? They stipulate the parenting time schedule.
Yeah, you can do that. And
How many overnights does that call for?
If you continue for the additional 3 months, based on the same schedule, 138 was my calculation.
the judge's question is, how much did the parenting times call? What did it show?
Well, they only did a 9-month calendar. And we...
Yeah, I've got it here, look.
Your Honor, I'm comfortable with with the court simply doing the same thing that I had done and continuing the calendar with the same schedule, and whatever number the court comes up with, I'm comfortable with.
I'm saying,
It's 138 nights, 138 nights. Does he exercises, is overnights?
Yes, they're following this parenting time calendar.
how can you exercise 138 nights when she has possession of the child from September through June while the child's in school? So you're
Because
getting
for
100
holidays, he's exercising more time.
We only got 365 days in a year now. So whatever court comes up with is fine with us.
If he's every other weekend is what, 26, 52 days?
Right, if you're doing just parenting time guidelines, that's 98 to 101. And then he's exercising additional
Another
time.
28 days, 30 days. Or 38.
Birthdays, extended holidays, rather than sharing it, he's having the majority of it. For example, on his weekend, rather than the child being returned on Sunday, he's being returned to school Monday morning. There's some additional
right.
overnights.
That sounds fairly reasonable. Has he been exercising the time, man?
Yes, and then we're supposed to switch it up next year, this year.
All right. So you can put in the order 138 days. Okay. And the next item.
Your Honor, with the new child support, that would cause, those stipulations would in fact cause a change in support. And husband was simply asking for retroactivity back to the date of the filing of his petition, which was June 1st of 2011. If the court is inclined to do that, I wouldn't have a problem, and I have discussed this particular issue with my client. I would have the authority to express this, that if the court were to apply retroactivity, any arrearage that mother owes, we could go ahead and decrease the amounts that father may or may not be delinquent for 2011 and 12, which is $1,300 and some dollars.
I mean, in arrears the mother might owe us. I mean, you're asking for speculation concerning that possibility. That was not a part of the original petition you had argued in the first place. Second of all, I think currently right now, the court's not in a position to deal with what you're requesting until the court figure out in terms of what the support will be based upon the proposal that you're going to submit to the court, what the current support will be. Then we've got to figure out whether or not there is in fact any arrears and what the total arrears are. In our original petition, we had...
I mean, we've still, he's got a point there, we don't know if there's any arrearages yet, for sure.
Can we stipulate that mother's gross weekly was the $498? I think that was reflected in your worksheet also.
I think we've stipulated that the support will be based on 40 hours a week, right?
Correct, that's as it
Which
relates
one
to
would-
dad's income. But if we stipulate that mother's is $498 a week
What was the
gross, then I have everything I need for a worksheet.
Okay, his mother's $498 a week gross?
Should reflect, yeah. Well, gross.
Okay, so you're stipulating, okay.
Some odd cents an hour.
Okay, so then, Your Honor, I can go ahead and prepare this order regarding these issues and simply reserve that once the court has the worksheet to rule on the issue of retroactivity.
We can
And
do
then-
that, then I'll rule on it.
And then if the parties would just simply maybe submit a proposed order relating to the issues that are remaining, the
Which-
retroactivity, the tax exemption.
Right. Well, a tax exemption, have you discussed exchanging it every other year?
We're not opposed to that.
Right now, the greater need is with the mom, Your Honor, in terms of the income.
How much does it save her?
In terms of the exemption? What do you get? Your tax return when you take the child?
It's, what is it, $2,500 credit, I think it shows in the thing.
$2,500?
$2,500.
She said about
The credit, it says that's what
$2,500
the child earned income credit is.
And that's what it would be for him?
We haven't done that calculation because he's never had the benefit of claiming the child. I can tell the court that I have a worksheet that we submitted at $85 which should be relatively close to where we're going to come out, and it makes the parties' contributions almost 70-30. So father paying 70% of the support, mother paying 30% of the support.
But the fact of the matter remains, the father gets $25 and some odd cents an hour. She gets $13 an hour. So you got a disparity there. She's been taking the child as a deduction for the last, 4 or 5 years since the divorce, period. So the court has discretion to look at
Is this your only child, ma'am? One?
I have two.
Two more?
I have two total.
Two?
Yes.
Are they both with this gentleman? Or
No, we
just-
both
just-
have separate.
Do you have an exemption on the other one? I
Yes.
mean, does the exemptions double? I don't know how they work.
I don't know.
Do you take the exemption for the other child too?
Yes. I'm the sole provider for the other child.
Why don't you discuss, I mean, if there's not a big difference with you taking 2 exemptions or just one, maybe you might want to consider trading it off every year. I don't think it doubles, Mr. Randolph. I mean, if you got 2 children, obviously you don't get a $5,000 exemption. I don't think it goes up. I don't know how it works.
I'd have more children if that were the case.
Yeah, so it may be not that much of a difference where you two could work that out, where it might be just a few dollars a week over the year. Okay? Why don't you look into that, maybe you could come to an agreement on either exchanging it or giving it to him if it's not a lot of money.
So, Your Honor, I will file the proposed order with the child support worksheet within 10 days, and then if council could have 30 days to try to work out that issue, and if we can't, we'll just add that to our proposed order regarding the remaining issues, the tax exemption, retroactivity. I'm just wanting to submit a proposed order, that way the court has what the remaining issues are, because this stipulation only deals with support, custody, parenting time.
Parenting time.
It doesn't deal with the tax exemption, retroactivity, and any arrearage, and then if we can't agree, the tax exemption. So that we don't have any issues that are left remaining and outstanding, I'm simply proposing that once I file this, we have 30 days to either reach an agreement on the tax exemption, and if we can't, we'll incorporate that in with our other issues and file a proposed order for the court on those remaining issues.
But I do need some, in order to determine the arrearage issue, we need to get this straightened out as to what was paid in.
And how long do you think, how much time do you think you can be able to get that information? Because you have to go to the clerk's
I
office.
have to go down there. I tried before, but I wasn't able to get anything because in their records, the way that the divorce was done and who put in the paperwork, they did it wrong, and that's why I called Montel and told him that he needs to call Ford because they wouldn't help me. Dearborn, I called them because according to Illinois, they were saying they don't have anything that shows that I've been receiving child support at all, and that's not the case. So that's why I told Montel he has to contact Dearborn, his payroll, and find out where everything is being sent to. Because when I went to Illinois, they said they don't show anything.
Yeah, and I recall. That is what she does like to.
It just wouldn't make any sense that several thousands of dollars have reached the
Well,
appropriate
I
place.
understand, but maybe
Yeah.
he should check with his, where it went to, and then she could follow up. That's why I wanted them, or some cooperation.
I can do that.
Yeah, I mean, he should at least have the document saying this is where we sent the money and this is what we sent, and follow up from there.
See if we can get something from the clerk verifying that no money's been paid.
Again, Your Honor, I wouldn't have an issue based on where I think the numbers are going to lie, that if the court applies the new support amount retroactive, that these alleged delinquent amounts are actually in fact credited. And what I anticipate would happen is that with the arrearage crediting both of those years and the $1,000 in attorney's fees, I think it's going to be a wash.
I mean, $6,000 in attorney fees. right?
$1,000 in attorney's fees. I think mother will ultimately end up with about, even if you credit 2011 and 2012, assuming that those are in fact arrearages, if you credit that against the arrearage that will form if the court applies the reduced support amount retroactive to date of filing, I anticipate there will be about $1,000 difference that mother would owe father, and given that father owes mother $1,000 in fees, it's a wash.
You're missing the point that our original petition back in October reflected an estimate between $30,000 and $40,000 in arrears.
Which obviously wasn't.
Well, we don't know that until we find out what the circuit court records reflect.
But, Your Honor, this is my issue. We've done a final hearing.
Well, we're gonna
The
find
issues are
out.
closed.
I understand.
The court already ruled and said there's
It's an
potentially...
issue whether how I rule on
They
retroactive.
have, and the court has not ruled on my petition for rule to show cause.
I've ruled that there may be an arrearage,
Yeah.
there may not be.
Right, and we don't know.
I think we did, the evidence did show that there was not a $26,000 arrearage, but there was a period of time that she was not getting money when he was sick or whatever.
So, and what happens if in fact the records reflect that no money was being paid, period? Which means that the court has to revisit that issue in terms of whether or not there is a contempt in reference to him. I don't know. I mean,
Well, whether it was willful, I think what the evidence showed that money was being deducted from his check. So whether it was willfully in contempt, I mean, there may be an arrearage, I agree, but I don't know about willful contempt.
I just simply want to narrow the issues down so that we have...
Well, I think I got a grasp. You can put it in your proposed order that the court will determine.
Okay.
and I'm still waiting on a check in reference to part of the fees that we were
If we may, Your Honor, if we can withhold that, given this issue of an arrearage, because if mom does in fact owe dad an arrearage, that could be deducted from the award of
That's a
attorney's
separate
fees.
issue.
Well, I awarded fees. I mean, we start deducting, just pay the fees, and then if there's another, she has to pay it back.
Okay.
All right, anything else? Mr. Randolph, anything?
Thank you.
Thank you, Your Honor.
All right.